always shifting. So the court can always depart from its own judgment because this is the apex court. You can't stick to a position that has become redundant because the society has progressed and things have changed. So they have a real way to depart from their own judgments. My position about dissenting judgments, these are very powerful tools in the development of the law. When a judge writes, feels strongly that this is my view of the matter, and let me put my thoughts on the paper. Sometimes that dissenting judgment has actually become strong because of the circumstances. It is sometimes very futuristic because the judge who writes a dissent is seeing to the future. And whereas these others may be just concentrating on the problem at hand. So we always celebrate a dissenting judgment because it opens up the space, allows people to express themselves. Amendments on the rules and the Supreme Court Act, I'm sorry, I have to look out to that at the Kenya Law reports.
Thank you. No, we have the amendments here. We already have them gazetted and everything. They are available right here.
Okay.
I wish you well, my sister.
Thank you very much.
Thank you very much, Honorable Judge. I will now request Commissioner Judge Majaja. Oh, sorry, Commissioner Judge Wasame. Ask questions.
Thank you, Professor. Judge, let's start with Article 45.3. Parties to a marriage and their equality of rights. Does marriage per se give one of the opposite parties propriety rights, and why?
Parties to a marriage and equality of rights to the property. It depends. If I got married today, I have my property. My spouse will not be entitled to my property. The property I had before marriage, that's my property. So, and vice versa.
So the
if it is
point
a man and he got married to a lady when he already has property, that is his property.
So
but when the lady comes into the marriage, let's say it's a house, and they develop it further and put developments, they live in it for many years. She, of course, acquires, occupational rights. Yes.
So, per se, marriage does not entitle one of the parties propriety rights. It's not a propriety relationship.
No, not in the instance. But once you live in it and you create other relationships and other rights within it, then those rights can be claimed. Okay. But once as you're entering, on the entry point, it doesn't.
Okay, my Lord, tell us 3 problems you will solve in the Supreme Court. 2 problems you will solve in the High Court within your next 30 days, if, God willing, you become the Chief Justice of the Republic of Kenya.
Thank you, my Lord Justice Wasame. That is at all wonder because I haven't even known what problems are there in the Supreme Court for me to say I will solve them in 30 days. 30 days, I think, is a very short time for one to carry out an evaluation of the existing institution and, identify a problem and begin the process of solving. I know there is endemic problem of backlog of cases across board, to a little extent also in the Supreme Court. Maybe a low-hanging fruit is to say, let us do a service week in the Supreme Court to list the matters that are pending, the ones which are owned, and see whether we can reduce them maybe by 30% within 30 days. But like you know, this is a Supreme Court which is established. So one has to, first of all, meet the judges, meet the registrars, identify what is the problem, agree what is the mode of resolving these disputes. So that is the Supreme Court. Did you ask about the Court of Appeal, or you went straight to the High Court?
Went straight to the High Court.
The High Court also, one needs to meet with the leadership of the High Court, the principal judge, discuss what is the most urgent and immediate problem that can be addressed within 30 days. And the one that comes on top of my mind is how we can also have a service week in the area which is most urgent. The principal judge will be able to tell me whether it's a criminal, that the criminal division is really hard pressed. So let's do a service week and get all the judges to hear criminal matters that week, and we reduce them by a significant percentage.
Okay.
Yes.
One of the court, in my view, that has lost its identity is the commercial court, which was meant to ensure that the process of resolution of dispute is efficient, effective, and within the shortest time possible. How will you address that problem?
Yes, that is a very important question, because the commercial court deals with businesses, deals with investors, and we need them to have confidence that when there's a dispute, it will be resolved expeditiously. So within the commercial court, we will look at multiple ways of resolving disputes other than through a hearing. There is mediation. And commercial transactions really begin with an agreement. People who entered into an agreement can always sit down and resolve the problem arising out of the agreement. So mediation, ADR, alternative dispute resolution, jump starting it, we'll see why things are going to clog the courts when they ought to go that way. And also embracing a case management system where parties file their documents, and then there is a call over before the case is fixed for hearing. Documents are agreed upon. So when you go for hearing, you don't even spend time on the witness box, other than if there is an issue to clarify. You just adopt the documents, you adopt the submissions, you leave the matter to the judge. The work is a lot also on the judge, but see how their capacity can be enhanced for them to work faster now that we have researchers. Develop some work tools and systems that assist the judge come up with a decision quickly. You have a template, what goes in the template, what the researcher information is supposed to bring and arrange, what the secretary is supposed to arrange, and then the judge is left with the decision making, judicious, to complete a judgment. So those are things we will have to discuss with the principal judge, and the judge is working there to see how they can unclog the system, but mostly using the other multi-door approaches.
Okay, what about the manpower of that court? Because I know you worked there and I worked there during Gisheru's time. If you are not delivering, you could not be in that court even for 6 months. Is there, how will you deal with the manpower to ensure that court satisfies the intentions why it was created in particular?
Yes, I agree, my Lord, that there could be a shortage of judges there, just like there's a shortage of judges across board. but even looking back at when we worked there, we were not very many judges, but I think we were able to bring the backlog of cases to, I think the oldest case would have been like 3 years when we worked at Milimani. So, which is still a long time, because I ran the judiciary transformation, the sustaining judiciary transformation strategy and the reports. The backlog should be a year. So, but this approach of case management, I don't know whether it's completely internalized and operationalized at the Milimani commercial court. So these are discussions to have with that court to see where is the cog, where is the hindrance. Why aren't we discussing this? Because every judge should also have their own docket. Like, for instance, when I went to Nakuru, there were so many cases. So we counted all the cases and divided them among the 3 judges. And subsequently, when a case was being filed, a new one, it was number 1, court number 1, number 2, court number 2, 3. 1, 2, 3. So all of us had equal number of cases. So if one judge is not performing, that will come out in the performance management, measurements, and also in your daily returns. So then you can do peer review on this one who is not performing. Say, look, you are bringing us backwards. Please pull up your socks. You ought to have finished 12 cases in a week. You are not finishing that. So, these are management, operational issues of how to effectively run a division.
Okay. The position I take is that currently the judges or the judicial staff are well resourced in terms of money, salary, and everything. Unlike during Gisheru's time, we have legal researchers in the High Court, Court of Appeal, and in the Supreme Court. We were very few then. We were around 42. But there was a lot of efficiency. But now we are almost 200 judges, and there's a lot of backlog. What is the problem, and how do you intend to solve?
Yes, this is a problem across board. And I look back because I was privileged to serve that period, which I mentioned when I served in Nakuru, when I served in Kitare, and also in the divisions. We were very few, but somehow we managed. Now we are so many, we are not managing. So that is an issue to interrogate. Is every judge having their own docket of cases? Or is cases all in the conveyor belt, going today, Judge A, B, C, D. Tomorrow they turn around, what was in number 3 comes to number 1. So it is standover generally, another tradition we found, which we worked against. So it is to examine those systems and see, because the one that works in my view and the one that I would be projecting and selling out is a case management system where somebody owns their docket from the beginning to the end, so that this file will not be before me today, tomorrow before you, my Lord, to the other day before another judge. These are always my file from the beginning to the end.
Okay, now let's discuss 3 areas. You said that you have not analyzed whether there are any problems in the Supreme Court, but I will tell you 3 instances, and you will tell me what you intend to do about it. The first one, my lady, is the case of Muriatetu. And the question before the Supreme Court was whether or not the mandatory death penalty is unconstitutional. But the court created, in my view, 3 problems which you need to solve. The first one can be found, and you see correctly also, to their credit, the advocates appearing for the petitioners, Mr. Ngati, a senior counsel, and Kilukumi, I thought also is a senior counsel, they raised only 2 issues in their submissions. But the judges captured what was the issue. And they said whether the mandatory nature of the death penalty and the 204 of the Penal Code is an attempt forcing the trial court to hand down a sentence predetermined by the legislature, and whether that is against the principle of fair trial. Those were the 2 issues which they raised in their submissions. But the court created 3 problems, in my view, which you need to solve. You need to give us a solution. And the first one, they dealt with the issue of life sentence. And this is what they said, my lady. We acknowledge that Kenya and internationally sentence should not only be used for the purpose of retribution. It is also for the rehabilitation of the prisoner as well as for the protection of the citizens who may be harmed by some prisoners. We find the comparative jurisprudence with regard to interdeterminate sentence is compelling. We find a life sentence should not necessarily mean the natural life of the prisoner. That is one of the first issues which they have created. And they said it could mean a certain minimum or maximum time to be set by the relevant judicial officer along
We have a problem here. Just 1 minute, we solve the problem of the microphone for the judge.
Sorry, Judge. And as I was reading, Judge, they said it could also mean a certain minimum or maximum time to be set by the relevant judicial officer along established parameters of criminal responsibility, retribution, rehabilitation, and recidivism. That is also the second problem which they have created, which was not part of the issues that was set for determination. In essence, they were saying in this judgment, life sentence does not mean life sentence. It can be interfered with by a judicial officer. And lastly, the third problem which I see is this. The Attorney General, the Director of Public Prosecution, and other relevant agencies shall prepare a detailed professional review in the context of this judgment and order made with a view to setting up a framework to deal with sentence rehearing cases similar to that of the prisoners herein. The Attorney General is hereby granted 12 months from the date of the judgment to give a progress report to this court on the same. And then again, they say, we direct that this judgment be placed before the speakers of the National Assembly and the Senate, the Attorney General, the Kenya Law Reform Commission, attended with a signal with utmost urgency for any necessary amendment, formulation, enactment of the statute law to give effect to this judgment on the mandatory nature of the death sentence and the parameters which ought to constitute the imprisonment. Those are three problems which is awaiting your resolution. How do you intend to solve them?
Yes, thank you, Myron. Thankfully, I've written an essay on the Muruatetu case, and it's part of my sample writing that I shared with the Honorable Commission, which shows that I'm acutely aware and that brings predictability, because I know if I have this kind of a problem, I will follow this procedure, and then eventually it will lead to substantive justice. And I belong to this school that asked, was the notice of appeal filed? Was it filed timeously? And I would overlook the fact that it was filed in Kabarnet Court as opposed to Nakuru or whichever the High Court that was hearing the petition. So like you say, this is a divided opinion, but since we are reviewing our positions before the next elections, these are matters which will be discussed by judges, and they come up with one common ground on the way to move forward in future, because perhaps it was not a mistake that they found in Cabernet. If that is where the case was heard originally, they probably overlooked the provisions of the law. We always say that ignorance of the law is never a defense, but you know, we encounter these problems every day. Depending on the circumstances, we allow when we are looking at the bigger picture, which is justice.
Thank you very much. And lastly for me, my lady, is there, I don't want you to comment on the merit of the case, but what you will do as a Chief Justice of the Republic of Kenya. The recent case of the BBI, where the Supreme Court, where the several cases were filed in the High Court and other cases were filed in the Supreme Court, I think by December or November, something like that, and the case was mentioned several times, but lastly there was a ruling delivered by the court on the 16th day of March 2021 saying, let the matters in the High Court be resolved. There is a school of thought that says, since the Supreme Court confirmed that this was a matter of great public importance, the High Court does not have jurisdiction. And it is only the Supreme Court that has jurisdiction. And that it was not right for them to refer the matter or to stay the matter pending the resolution of the High Court matters. What will you do? Because this is the apex court. And it must lead in terms of jurisprudence. And it must lead in terms of issues affecting the country. What will you do if you are the Chief Justice?
Thank you, my lord. Those are very turbulent, sensitive matters because they are live. I cannot really discuss them because they are sub judice. But since you have cautioned me not to go to the merits of the case, I'll just tell you what I can do. If these are matters of general public importance that affect a close section of Kenyans, I will read those files. We will call a conference of judges of the Supreme Court and discuss and see the way forward, and then move from there. Whether the Supreme Court takes over all the matters that are pending in all the courts and hears the matter, that will be, a discussion arrived at from a participatory and consultative forum of the judges of the Supreme Court.
Sorry, this is my final question. Final question. I'm sorry. And I just forgot to ask a question that has been given to me by the Commission. How will you resolve the dilemma of the 41 judges? And this is a standard question for all candidates.
Thank you very much. This one must be resolved. Like I said, through negotiations. There is one major problem I see with perception of what is judicial independence and what is interdependence. Because we are independent. The judiciary independence is secured in the Constitution. And nobody can claim to take it, and nobody should attempt to take it because it will be unconstitutional. But the judiciary is accountable. They go hand in hand. And the judiciary is interdependent because we all serve Kenyans. The executive serves Kenyans. The legislature serves Kenyans. Therefore, when the right hand doesn't know what the left hand is doing, or is not agreeing with what the left hand is doing, the body, which is now the Kenyans, are suffering because of the standoff. So when I was preparing for this interview, I know of the National Council on the Administration of Justice that brings all the actors together to discuss coordination of the administration of justice. I've also read the Intergovernmental Coordination Act that makes provisions on how the central government relates with the county governments. And there is a whole act of parliament complete with the mechanisms of how to deal with stalemates and standoffs. When I looked at the judiciary, we are interdependent as far as the delivery of service is concerned. And that's our core business, delivery of service to Kenyans. We get our money from the consolidated fund. We are part of the government. So we need to explain what is interdependence. Where do we come together on matters of administration of justice? The human resource, the capital, the budgets of the judiciary, the infrastructure, all those are projects that involve everybody. So we need an act of parliament operationalizing the NCAJ. And therein a mechanism for resolving any standoffs. Regular meetings with the executive with the legislature, so that when the CJ is seen with His Excellency the President, people do not think that they are discussing a case, because our independence is in decision making and in hiring. The other things, we are interdependent. When the CJ is seen with the President, they are discussing matters on administration of justice, that everybody is responsible. It's not a beauty contest who serves Kenya better. Is it the executive, the judiciary? We are all in it. So if the judiciary is failing, the economy is failing because disputes are not being resolved. The president gets affected and everybody gets affected. So we must discuss this issue of 41 with the president in that atmosphere of we are serving Kenyans, all of us, and we are concerned about the administration of justice. And we find out where the problem is, resolve it, and get the judges in office.
Thank you very much, Judge, and I wish you well.
Thank you.
Thank you.
Thank you very much, Judge Koome. Honorable Commissioners, I would want us to take a 5 minutes break. I think we need to fix the lines so we are all together. So, Judge, you can take some water, a health break, 5 minutes. We come back 11:05. Thank you very much.